Hi, my name is Richard Stovey. I'm a lawyer with the Field Law Intellectual Property Group. And the question we're looking at today is who owns the company's invention or intellectual property? So an invention or intellectual property can cover all kinds of different things that may be valuable to a company. We're going to talk about two main categories, okay? And we're going to talk about things that fall into the Copyright Act category and things that fall into the Patent Act. Really, when you look at a company and the kind of workers it engages, legally we kind of divide it into two main categories. Either you've got employees or you've got consultants. I'm simplifying, so there are nuances to this. So first we'll look at copyright. Okay, so copyright is a category that's often associated with things like music, paintings, film, anything that's kind of visually captured and expressed and it's original. It's going to be caught by the Copyright Act. And so that can also include things like software and algorithms, all kinds of content that's captured in writing that may be confidential to the company, proprietary to the company, and has value. So this is an important category. So first let's look at the Copyright Act. So if it falls into the area of copyright, it's governed by the Copyright Act in Canada. And we talked about two different kinds of workers, one of which is an employee, one of which is a contractor. The Copyright Act actually says that the first rule is that the author of the work, so the person who creates the material, is the first owner of that material. But there's an exception. The exception is that if it's created by an employee in the course of their employment, then the employer will own that. So it's very important to know whether the worker you've got is an employee or a contractor. And if they're a contractor and they're not covered by that kind of special clause that in the Copyright Act that deals with ownership of works created by an employee, then you want to make sure you've got an agreement with that person because they may own what they create. That's sort of the default rule, is that they're the author of it. If it's original, they've created it and they own it. So the only thing that displaces that is a contract or an agreement that specifies that the company is going to own it. Now let's turn to things that fall into the realm of patents. Okay, so if it's an invention and it's covered by the Patent Act, it may be patentable. It may be an invention that's not patentable, but we're going to look a little closer at the Patent Act, and the Patent Act actually doesn't have that kind of clause that the Copyright Act. So the Patent Act is silent when it comes to employees and the employee-employer relationship. The default rule, the kind of the basic starting point under the Patent Act is that the inventor is going to own their invention. So if we look at the employee category, you want to look at a bunch of factors that courts look at to determine whether the invention created by an employee is going to be owned by the employer. We won't go through every single factor, but one of them may be, for example, was the person hired to or engaged to invent? Because there's nothing specific about employees in the Patent Act, this will apply to both employees and contractors. And so, again, the important thing to remember is the written agreement that you have in place with your workers. If the written agreement is crystal clear, whether they're an employee or a contractor, that the invention is going to be owned by the company, then that will remove all doubt. And you won't have to worry about what the default rules are because you clearly dealt with that in the terms of the contract. If you deal with the ownership of inventions and cast the language broad enough to cover both things that are covered by copyright, things that are covered by patent law, things that are covered by other areas of intellectual property law, and the contract is made clear as to who's going to be the owner, that will be the best course of action to avoid disputes and avoid confusion when it comes to that critical moment when you've got an invention or a work of value and everyone's scratching their heads trying to figure out who owns it. So that preventative work done at the front end to clarify all those relationships and all that the ownership questions, that will pay off. So that's a little discussion about the ownership of intellectual property by a company. And we are here to answer more questions. We look forward to talking with you.